Hi, everyone. Thank you so much for joining me. I'm Nairobi, and I'm the host of the Power to the Flower podcast. This is episode 4 of season 2, and we're going to get right into it. We're going to just start talking about the Massachusetts Cannabis Commission and the proposed legislative changes that are coming out of the Statehouse right now from the House side that could really impact how the cannabis industry shakes up, not just in leadership, but also some different proposed regulatory changes and its impacts to Black and Brown communities. Just before House Bill H 4160 passed favorably out of the Joint Policy Committee on Cannabis in the Massachusetts State Legislature, we heard some news about Commissioner Nudis Camargo's actually stepping down, and her last day was on May the 23rd of 2025. Now that Nudis Camargo is no longer a commissioner, we have 2 empty seats on the Cannabis Control Commission. The former empty seat was recently held by one of the most controversial chairs, Shannon O'Brien, and due to her being fired and or suspended by the person who appointed her, which was Treasurer Deb Goldberg, we had seen a litany of different news outlets covering all of these different issues that were coming out of that case and that lawsuit. Everything that had to do with the former chair was controversial, from the appointment of her position all the way up until her dismissal and then thereafter. The state legislature heard the industry experts and stakeholders and heard the need for minimizing some of these controversies. So they proposed a couple changes. And this is what is in the bill of H 4160. House Bill 4160, an act at modernizing the Commonwealth's cannabis laws, is currently a bipartisan bill that was supported by folks like Rep. Kilcoyne, Rep. China Tyler, Rep. Dan Cahill, and Rep. Sam Montano over in Boston. We had a couple different folks that were interested in supporting this bill, and a total of over 15 sponsors, and that number may just be increasing as we go forward with this bill. It shows that the bill has strong initial support, not just from legislative representatives, but also from the industry as well. This sweeping legislation can cause an overhaul of how we actually do business in the state of Massachusetts. And it's important that we talk about this because of its potential impacts to Black and Brown operators and also to Black and Brown med patients. The first legislative change that we see is that the Cannabis Control Commission will go from 5 member appointees to just 3. And instead of having a mix of the Attorney General or the governor or the treasurer appointing some of these folks, we're going to have instead just the governor appoint those 3 members, including the chair of these positions. The chair will be able to hire and fire the executive director, and solely the chair of the commission will be able to have this power. This was a part of the controversy that the former chair, Shannon O'Brien, had with regards to her powers and whether or not she can do that under the law. This bill actually makes it so that it's very clear and clean as to who has the power to do what under these circumstances, with just 3 commissioners appointed. Now, with the 3 commissioners being appointed solely by the governor, you can also see why having an input on the governor's race, the upcoming governor's race, or any type of governor's race moving forward in the future for cannabis is important, that the cannabis industry shows up, because these positions will actually be shaped by some of the politics behind this, unfortunately. So I want folks to understand that as we move forward, because that just sort of centralizes power, not just by just keeping it to a 3-member minimum, but also by which they are appointed from. The bill doesn't just talk about the proposed changes to the Cannabis Control Commission's leadership. It also highlights the changes to retail license caps, which means any marijuana operator can actually expand their licenses from 3, as it currently stands, it's capped at, to 6. So this means that they can have up to 6 retail stores, and this does not apply to other license types. So this wouldn't go for cultivation sites where you can't have 6 cultivation facilities, you can have 6 product manufacturing facilities, or so on and so forth, right? What this does, it keeps it exclusively for retail shops. A part of why this is a concern is because equity activists are seeing this as a potential for multi-state operators to sort of squish the small business operator. Black and brown communities, and specifically in cannabis, those social equity applicants are usually not doing more than 1 or 2 stores. They could if they wanted to, of course. We're capped at 3. But the problem is having access and opportunity to acquire some of these locations, which requires a considerable amount of resources. And those who are already at that level where they can purchase more than three will likely be multi-state operators or larger corporations in cannabis. And the reason why that's important is because some of these businesses on the opposing side of this argument are saying that their businesses aren't viable to be sold because they're not actually making a profit. CPAs have outlined ways that the profit is made through the cannabis industry if you have more than three businesses in retail. The reason for that is because there's so many operating fees that sometimes it's very difficult to even keep one business sustainable. And it's a little bit more complex, but I just kind of want to give an overview of two sides of that argument. What I personally believe is that there should be a retail cap. Okay, I do believe that this can be competitive for the cannabis industry. Some folks are going to want to, go ahead and open up 4, 5, 6 stores. But the issue is that we have zoning laws that really prohibit where some of these businesses can be anyway. So the cannabis businesses that are subjected to zoning laws are also subjected to limited buildings that are available to be able to even have a store. And then as you raise the license cap, you're also raising the market. The market is becoming more flooded, and the increase in revenue diminishes because the increase in profit diminishes, as well as the increase in revenue, because there are more options for consumers to go ahead and purchase cannabis. That is a part of the issue why cannabis social equity advocates are saying no to this provision in H 4160. Another key provision is that marijuana treatment centers, or MTCs, where medical cannabis is normally distributed and sold through, will no longer be vertically integrated. However, the non-vertically integrated license types will only be available to social equity licensees for the first 3 years of this bill passing. This is amazing because this means that if some small businesses are already doing retail, they can also tap into the medical market and expand access for Black and Brown patients. This is crucial and incredibly important because some of the Black and Brown operators are usually setting up shop right in their own neighborhoods if they possibly can. A lot of the reach there will also go directly to those communities that feel comfortable showing up to those shops. And if they can get their medical cannabis in the same facility, then there's incentive to still have a medical marijuana program. Another provision to take note of is the limitation of sales for hemp-derived or CBD consumable products. What this means is that now any consumable CBD products or any hemp-derived products must be certified by the CCC. This also takes hold of the sort of gray area market that we have been seeing impacting the cannabis sales overall as well. Some people may be able to access a THC Delta 9 drink that is a CBD drink that wasn't, under current terms, not being regulated by the CCC or even the state legislature. So now this bill actually adds words to that and makes it so that any consumable CBD product is sold from a store, there is a fine associated to that, especially if there isn't any certification from the CCC allowing or granting that business to do so. But the part I don't want to skip over is the part where I said that any retailer that sells consumable CBD products will have to register with the Cannabis Control Commission. The reason why that is important is because we do have CBD stores that are in other Black and Brown communities. I just want to point out Lawrence, for example. Lawrence is a no town, but there is a CBD store there that is owned and operated by a what would be a social equity applicant if they had to apply under this new statute. So this person is now going to be affected because now their products are going to have to be regulated, and business is not usually welcomed in no towns already. So even if it's a CBD store, will this mean that now the CBD stores in no towns will have to be also considered a no product being sold there? There's a lot of questions still being circulated around that. What it means is, how will those CBD stores have to now identify? Will they be having to go through a different process like zoning and things like that, just the same way that cannabis stores are also, if required, to be in specific zoning? So things to keep in mind there. This would allow for local boards of health to have control over supervising, overseeing any of these unlicensed hemp stores and giving local authority to be able to enforce the closure of some of these stores, or the reporting of some of these stores. On a local level, that makes sense because local boards have the authority to do that anyway. However, what we again run the risk of is for some of these no towns, what does that mean for the CBD stores that are currently existing in this gray area? How will they have to respond? And what will be the legalities for that small business owner in this process when they've already been told that they can exist under this provision, but now switching it to yes, now you can? Those no towns will have to respond and question whether or not they're welcoming CBD in their town still, or if they're going to treat it as regular, recreational cannabis. Okay, so another key provision is that the Cannabis Control Commission would be having a public post system, which would be similar to like how the Alcoholic Beverage Commission does theirs. And the public post system really is just related for accounts receivable. So for those who owe anybody money in the industry, another business owes another, et cetera, and there's been X amount of days and they haven't posted, they haven't paid. Um, that means that they will go into this public post system for public shaming, essentially. And that is supposed to bring about a public awareness for everyone in the industry to know who is in debt to who, and so that folks can be more discreet about who they do business with. And this is important because, regardless of the fact, everybody may be in debt to someone, but you need to pay your bills in order for your business to continue to be not just respected, but profitable in and of itself, obviously. But of course, we know that this industry has been a failing industry due to high regulation and lack of leadership and the lack of changes to regulatory needs that we're now seeing. So hopefully, this gives some credence to some of the things that people have been, in essence, ringing the alarm about for a long time. But most importantly, so that folks can get properly compensated for what is due and owed to them. So good luck to everyone with A&R. Those who are, excited about this, I'm sure you have your reasons, and those who are terrified, that same still applies to you too. There will also be an industry anonymous reporting portal for any illegal practices, such as testing fraud, anything that has to do with a practice that isn't legal, but there seems to be no oversight on that. There's going to be a system where folks can anonymously report their concerns. This is super important because a lot of people, especially those workers in the industry that are seeing some of these things and are alarmed by certain practices by their employers, are unsure if they should speak out on it because of the backlash that they might receive, and also because there isn't a safe space to be able to do so. There isn't a direct source for folks to be able to do that other than probably an email to the CCC directly or even a legislator. Most folks don't actually do those things though, but if there's a direct line, there's ways that they can probably push this up the line. So it's important for us to have industry oversight. So I'm excited about this bill and what those provisions might bring about. Overall, the changes have impacts to Black and Brown operators, patients, even the communities that are hosting some of these places will have to confront themselves with what the new changes will be and how to best operate in this industry. And now we're going to see a lot more coming out of the State House, because now the next steps will be this bill landing in the House Ways and Means. After the House Ways and Means, it goes over to the Senate, and then the Senate deliberates its changes or what it would like to see. Upon that, we'll probably see it going over to the governor's desk, or if there's any need for any additional changes or hearings, etc., you'll probably see that as well. But we'll be following this closely, see what the progress will be. The changes will probably take effect some point next year. We don't know, or maybe the year then after, if this goes swiftly according to what is being planned. But if you are concerned about any particular provision in this bill or any of the policy proposals that don't seem inclusive to you, your community, or even the thought process, then certainly reach out, because there will be opportunities for you to do so. We should not lose hope, because this is why we do this, okay? And with that, I leave you all. Hopefully, that was a good recap. For good sources to follow on this, there are legal firms that work on this. There are other folks that do this just through the trade associations, like Ryan's Massachusetts Cannabis Coalition. There's also the Massachusetts Cannabis Equity Council, and then there's Mass Eon, of course, the Equal Opportunities Now. Folks who are really on the ground, just shaping the policies and getting involved. If you're interested in even doing more of that work, or even if you're curious about questions from either side of the coin, reach out to these resources because I'm sure that they would be able to answer that for you, especially as the bills move forward. And that's it. Thank you so much for listening and tuning in. If you have any questions about this and you want to continue the conversation, feel free to message me or reach out to me directly on the Power to the Flower podcast Instagram. We also have our email and links all there. So stay in touch. And those of you on YouTube, feel free to write in the comments and let me know what your questions or thoughts are. And if you're listening to us audibly, feel free to just reach out to one of those mediums and we will get in touch. All right, y'all, that's it. Till next time. Bye.